Very kind of you.
And we have amidst of us many eminent academicians, scholars of law. Professor Dr. Sudesh, the former director and principal of University Law College, Bangalore University, who is here amongst us. I welcome him, Professor Sudesh.
Thank you.
And we have amidst of us the law principals of various institutions across the country. I'm immensely happy that there has been an overwhelming response in the form of registrations coming from more than 12 states in the country. It shows that how much the law teachers and the law academicians are interested in enriching the knowledge. And we hope that webinar will certainly make you all very much enlightenment on the topic that we have chosen to this webinar. Friends, a judicial review the process under which the executive or administrative actions are subject to review by the judiciary. An authoritative court which has the power of judicial review may invalidate the legislation that are inconsistent with the Constitution. In a democracy where there are separation of powers, judicial review is a mode which keeps checks and balances to control the legislative branches when they exceed their authority. Of course, this doctrine varies between the jurisdictions and between the procedures, and also it may differ between the countries. And as far as the judicial review is done by the constitutional courts, Supreme Court of India and High Courts, and these courts have got power to invalidate the laws, acts, and the governmental action which violate the constitutional provisions and even the constitutional amendments if they violate the basic structure of Indian Constitution. To know more about the topic, the history of judicial review, the scope, the importance as a basic structure of the Constitution, we have got the most eminent scholar on the topic. We have made a mark for himself in legal academics, yet very humble in his approach, Dr. Mohan Bolla. And I welcome him once again to this webinar. And you all know that KG Society is always known for its quality in imparting education in all the streams from KG to PG, including medical, engineering, dental, law, engineering. And we continue this process throughout the year through our webinars and through our online academic activities. With this opening remarks, I welcome you all once again to this webinar, and I pass the mic back to Priya. Over to you, Priya.
Thank you, sir. Thank you so much, sir, for welcoming the gathering. To introduce the chief guest, I request Srimati Savita Patan Shetty, Assistant Professor, B.V.Bellad Law College, Belgavi. Over to you, ma'am.
Good morning to all. It's my pleasure to introduce chief guest of today's national webinar, Professor Dr. Mohan Bolla, Principal Christu Jayanti College of. Born and brought up in a historical town of Machilipattam in Andhra Pradesh, graduate in BSc from Noble College, Machilipattam in Andhra Pradesh, completed his bachelor's and master's in with labor law specialization from University College of Acharya Nagarjuna University with a Judicial. Sir has done his doctorate in empirical research on the topic Special Economic Zones Act and Rights of Project Affected Families from Andhra Pradesh. Sir has worked as principal to various colleges in Andhra Pradesh, was a professor in law in Christ University, Bangalore, professor of law at Alliance University, Bangalore, was associated as program officer and director with Jana Sikshana Samsthana, sponsored by Ministry of HRD, Government of India. Sir has taught various subjects like constitution law, administrative law, commercial law, arbitration, labor laws, IPR, evidence, to name a few. Sir has published more than 30 articles in reputed law journals, including ILI and journals of constitutional and parliamentary studies. Sir has been regularly contributing one chapter, co-authoring with Professor Dr. Annam Subramaniam, Annual Survey of Indian Law published by Indian Law Institute. Sir has extended resource support in many national seminars organized by Mahela University, Osmania University, Sri Krishna Devaraya University, Hindustan University, National Law School of India University, and many more other universities. Sir is an academic council member to Karnataka State Law University, Hubballi. Sir has been BOS member and research committee of several universities. Sir has presented research papers in various national and state seminars organized by various universities in India. With this brief introduction, I welcome you, sir. Welcome you once again. Thank you.
Thank you, ma'am. Dear participants, now we have arrived at the part of the webinar for which we all are eagerly waiting. So I request the resource person and speaker of today's national level webinar, Professor Dr. Mohan R. Bolla, Principal, Kristu Jayanti College of Law, Bengaluru, for his presentation. Sir, kindly take over the session. Sir, please.
Very kind
Over
of
to
you, Miss Priya, Dr. Jayasimha,
Thank you, sir.
Dr. Sudesh. The galaxy of participants from, as was stated by Dr. Jayasimha, as many as 12 states, and the participants are very much inspiring. The inspiring presence of the galaxy of participants would definitely make every program successful. We'll start with a small prayer. Sahana vavatu, sahanau bhunaktu, sahaviryam karavavahai, tejasvina avadhitamastu, mavidvishavahai. This, as a matter of fact, paves the way for a mutual learning. And I consider myself as a student of law permanent, because teachers ought to be permanent students. And we need to keep the wick burning always, and more especially with respect to the legal education. You need to update yourself and to be fit with all the updates. We try and analyze the various issues pertaining to the legal education as well as the law, which is meant for regulating the human relations and ensure that there shall be progress and a progressive society. And in India, we have the Suprema Lex, namely the constitutional law, the Constitution of India, which has been enacted and enforced in 1950, and we had just celebrated the Republic Day. And this Suprema Lex, as a matter of fact, had been accoladed as a very great document, an organic document which has been living. Even after 7 decades, it has been continued, and the life of it could be continued because of the doctrine which we are now going to analyze for the coming 1 to 1.5 hours or so. As a basic structure of the Indian Constitution, this doctrine would definitely have been helping the courts, and the country could keep the law, the Suprema Lex, intact. And that kind of basic structures are the protective devices for upholding the Constitution and its values that have been enshrined by the founding fathers. And as a matter of fact, this we have adopted the Constitution wherever there has been some part of the Constitution which had been working well, as extensively studied by eminent scholars in the form of the drafting committee members, including Dr. Benegal Narsingrao, who had been the advisor to the drafting committee. And we have the eminent scholars in the form of the drafting committee chairman, Dr. B.R. Ambedkar. And regarding the adoption of the systems from various other constitutions, Justice V.R. Krishnaiyer was talking about this, and namely the not the Potomac but the Thames, the fertilizers flow of the Yamuna, if we may adopt a Reverian imagery, he said, and that speaks a lot. Generally, we have adopted the Anglo-Saxon jurisprudence basically, and this judicial review, as the expression conveys, it is the power of the higher courts to verify the constitutional validity of any law to protect the constitutional rights. And my dear friends, there is somebody who is continuously striking something on the slides. I think he doesn't want the session to go on.
Request the participants to kindly restrain yourselves, because more than 400 participants across the country are participating here.
Yeah.
Kindly don't put such kind of acts here, because it's an academic exercise which we are doing it very seriously for the enrichment and learning of all the people here. And Dr. Professor, one request is make it into a slideshow so that
that's correct. That I'll do that. I'll do that.
Continue, please.
This is a slideshow, I think.
No, it's not slideshow. You are getting what you call it.
I'll just do that. Yes. Now it's a slideshow. So this judicial review may be defined as a check or scrutiny of any law. In the modern terms, scanning and scrutinizing anything.
Sir, sorry to disturb you, sir. It is just a normal view. Please go on the slideshow tab, sir. Slideshow tab. You are in the view
tab only. I had just clicked this slideshow slab
click
only.
F5. Click F5, sir. F5.
F5.
Yeah.
Okay. I did it.
No, you are in the tab called view, sir. View tab. Go to slideshow tab. Like after that review, from last, it is the third one.
Sir, shift and F5, sir.
Shift.
We just want to tell you for the full screen.
At the bottom, sir. It is there in the bottom. You can see that.
There.
Yeah. You are in the view tab. You can also use file, home, insert, right? Similarly, you have slideshow tab. Go there and then you can.
Yes, sir.
Yes, sir. Perfect. Thank you.
Yes, Mohan.
Okay.
That's fine.
Now, judicial review may be defined as a check or scrutiny of any law by the higher courts, namely the high courts and the Supreme Court, for the
Yes, sir.
validation or invalidation of the law,
Hmm?
for the violation of any fundamental rights, or for the verification of the law to be declared inter vires or ultra vires the Constitution. This being the definition, we try to look into the various definitions of given by various authors like Henry Abraham, who was defining this judicial review in his book Freedom and the Court, Civil Rights and Liberties in the United States.
In progress.
Judicial review in the United States comprises the power of any court to hold unconstitutional and hence unenforceable any law. Here, as a matter of fact, just now I was giving you a kind of definition which would say that only higher and constitutional courts have that power. But the under the American Constitution, even a petty court can invalidate a particular law, and it's of course it's a rare issue. Anyway, the highly significant power of judicial law is possessed theoretically by every court of record, it is said by Henry Abraham. Anyway, and the roots of this doctrine of judicial review can be traced from Dr. Bonham's case, wherein Edward Cook, though it is C-O-K-E, Coke, but it's pronounced as Cook. This Dr. Bonham, who was practicing without the so-called license from the World Royal College of Physicians, for which he was prosecuted and convicted directly by that Royal College of Physicians. And later on, he had moved the court and it was considered as a wrongful prosecution and conviction also. And that was considered as violating the common law rights of the particular individual and in the common law countries. So Dr. Bonham's case was the originating case where we get this judicial review, and it was held in that particular case to the effect that there could be invalidation of the Parliamentary Act, which if it violates the common law rights also. And later on in America, we have the celebrated Marbury versus Madison case, and the origin of the power of judicial review is traced to this. Even in India, and many judges have quoted this particular case, wherein Chief Justice John Marshall was categorically saying that the province and duty of the judicial department to say
with Bluetooth.
the judicial department to say what the law is, and a law repugnant to the Constitution could be declared void. And that had been the originating factor, or the roots can be traced to the American system as well as the British system. And we have in India, to a certain extent, taken that concept of judicial review in a typical way. And there had been a trend very well established right from even A.K. Gopalan case, wherein the court speaking through the CJ Kania was saying that the inclusion of Article 13 class 1 and 2 of the in the Constitution appears to be a matter of abundant caution, and even in their absence, if any one of the fundamental rights was infringed by legislative enactment, the court has always the power to declare the enactment to the extent it transgresses the limits invalid. So even when there is no specific provision to the effect that a law which is inconsistent with the fundamental rights is void to the extent of its inconsistency under Article 13. Even without that, the court was lamenting that there could be invalidation of any such law which infringes fundamental rights. That was the attitude, and that was what was the understanding of even the first Chief Justice of India. He was even stating that in a meeting, he was expressing his view that the courts in India, especially the constitutional courts, would play the vital role of even when there is no opposition party, and if the opposition is very weak, the court would definitely step into the shoes of the opposition, and it can even control the legislative excesses and even the administrative excesses. And Justice Patanjali Sastri in Vijiro case had maintained that our constitution contains express provisions for judicial review of legislation as to its conformity with the constitution. Sorry for that interruption. And we have a catena of cases, and I need to at the outset confess that as a learner of the constitutional law, I'll be touching upon certain important case law only through which this concept can be explained. And these eminent judges who were part of the largest bench of the constitutional, largest ever bench constituted in India so far, they were so upright and brave that they had taken their viewpoints very strongly, that there are certain basic structures which cannot be amended, and without demolishing the entire structure, you can go to the extent of amending any part of the constitution. And the basic structures mostly they have derived from
ನಾವೇ ಕಾಲೇಜಿಗೆ ಬರೋದು ಇಲ್ಲಿ ಬರೋದು ಟೈಮ್ ಪಾಸ್ ಮಾಡೋದು ಹೋಗೋದು ಇಷ್ಟೇ ನಡೆಸಿ ಮಾಡಿ ನಾವು ನಿನ್ನ ಜೊತೆ ಸೇರಿ ನಾನು ಹಂಗ ಓದೋದಿಲ್ಲ ಬಿಟ್ಟು ಫಸ್ಟ್ ಸ್ವಲ್ಪ ಚಲೋ ರೇಟಿ ಬಂದು ಬೆಳಿಗ್ಗೆ ಬಂದ್ರೂ ಕ್ಲಾಸಿಗೆ ಅಟೆಂಡ್ ಆಗ್ತಿದ್ವಿ ಒಬ್ಬಕ್ಕೆ ಅಟೆಂಡ್ ಆಗ್ತಿಲ್ಲ ನಾ ಬಂದ್ರೆ ಇಬ್ರು ಬರ್ತೀರಿ ಬೇರೆ ಇಲ್ಲ ನಿನ್ನ ನಾಳೆ ಬೇಡ
ಬರ್ತಾರೆ ಅಂತ ನಾವು ವೇಟ್ ಮಾಡತ್ತಿದ್ವಿ. ಹಲೋ
And in the sorry for the interruption, my dear friends. This in Kesavananda Bharati case, the court has recognized judicial review as a component of the basic structure of the Constitution. And the fundamental importance of the freedom of the individual has to be preserved for all times to come, has been what has been categorically observed by the Supreme Court through the largest bench, speaking through the then Chief Justice S.M. Sikri. And he had, or the judges, the majority judges have identified several such basic structures in the Constitution, including the supremacy of the Constitution, republican and democratic form of government, secular character, separation of powers, and the implicit under the separation of powers you have again the judicial review, secular character of the Constitution also, and then federal principle, dignity and freedom of the individual as such, and this socio-economic and political justice contemplated under the preamble, the unity and integrity of the nation, and then sovereignty of India. And as such, various such structures have been viewed by these judges. And the amending power of the legislature, especially the parliament, has been limited to the basic structure or framework of the Constitution, and it must survive any amendment of the Constitution by just invoking the power and in pursuance of any directive principle. You are not expected to demolish the entire structure, and without affecting the basic framework of the Constitution, you may amend any part of the Constitution. And that paved the way for such occasions for the court to expand the frontiers of the rights of the people. And in Maneka Gandhi, the landmark decision wherein certain qualifications for the procedure established by law have also been read into in a way. A procedure established by law cannot be unfair, unjust, and unfair, unruly. As such, we see a catena of cases whereby we can vehemently say that the Supreme Court in India has been acting as the guarantor of the fundamentals, and it has been preserving the basic structures, and the Constitution could live long in view of these basic structures, especially the power.
पासवर्ड और नहीं सर, राइट साइड में देखिए, आपके दाहिने तरफ देखिए, फॉरवर्ड पासवर्ड का ऑप्शन देखिए.
Please continue this webinar, sir.
One, yes.
And even in Minerva Mills, the court has continued its wisdom in invoking the basic structure theory. And though Justice Chandrachud was in the minority group of the judges who were in the Kesavananda Bharati case, but he had continued the tradition. And in a way, during that period itself, just before Minerva Mills case, an attempt was made by the then Chief Justice A.N. Ray to constitute another bench of 13 judges to review the Kesavananda Bharati verdict. It could not be made possible, and none other than Balkiwala himself was opposing it, and therefore the court was forced to withdraw that. And then the trend continued in Minerva Mills and in L. Chandrakumar and many other cases. The judicial review of administrative action and legislative action and the judicial decisions have been identified as the facets of judicial review. And under the Constitution, acts of Parliament are subjected to judicial review, particularly when they are said to infringe the fundamental rights. That has been the viewpoint expressed by the Ketinoff decisions and judgments delivered by the Supreme Court, and the trend continued unabated. And even in Indira Nehru Gandhi versus Rajanarayan also, the same Chief Justice A.N. Ray was to accede to and sail with other judges and accept that the power of interpretation and judicial review cannot be transferred to any other wing of the state. And in S.R. Bommai, as you are well aware, the leading judgment were the administrative action of the central government through the presidential orders, etc., imposing president's rule on the states, has been condemned, and several guidelines have been laid down by the Supreme Court. And this could happen only because of the fact that it had got that power of judicial review. And as such, the trend continued. And here, the so-called satisfaction of the president while making a proclamation under Article 356 was held as justiciable, in the sense it can be tested through that tool under the touchstone of the constitutional values, including that particular value, namely the judicial review. So subjective satisfaction, it cannot be subjective satisfaction, and there cannot be any whimsical exercise of power by the center. And even in a situation where there were orders by the, or in a way there was a dramatic clash between the House and the High Court in Ray Article 143, where the advisory jurisdiction of the Supreme Court has been has been utilized by the President of India at that time. And the fact that a particular journalist who was ordered to be arrested and brought to the house for admonition, when he approached an advocate, and through the advocate, Mr. Solomon, the advocate, and the judges who were deciding the case, giving a stay order against the order of the house. The house was so furious that it had even issued orders to arrest the judges. And then at that juncture, the entire house, entire judges of the High Court sat, and there was a situation where at that juncture of having some such undesirable developments happening, the President of India was intervening, and the matter has been referred to the Supreme Court under Article 143. And this could happen because of the such value-oriented principles and phenomena that have been actually impliedly considered by the court, and we could have the constitutional values and the wisdom preserved throughout. And the latest decision of the Supreme Court just delivered yesterday, that there could be judicial review relating to the actions of the House if they are detriment to the constitutional values and wires that are established. And it had invoked the power, and it had laid down to the effect that there can be suspension of the MLAs not more than one session. Up to one session you can exercise that, and that would affect and demoralize the democratic values that are established in the Constitution of India. As such, in all, what I want you to appreciate and understand is that there had been this doctrine of judicial review, which could keep the constitutional values preserved, protected, and the Constitution itself, which is a very great document wherein there has been scope for very good living, and there had been scope for development through the effective implementation of the Constitution. By all means, we are expected to protect and preserve the values, and the court has been doing its job with its utmost clarity by invoking this kind of verdicts, namely the kind of supremacy attached to the values, and a value-oriented document in the form of the Constitution of India should by all means be preserved and protected, and that could happen through this doctrine of judicial review. And I had in fact, keeping in view of the time, if we do not have the constraint with the time, we can have this video watched, and then we'll take up some queries by the participants, and there can be a mutual learning process in a better way. Please watch this, the video relating to Marbury versus Madison.
Thank you, sir.
Sir, it is not audible.
Hello? Hello? Hello?
Yes, sir.
Bolla sir?
Yes, sir.
Audible, it is not audible. This video is not audible, Mohan.
1 second. I'll check.
Mohan sir?
I'll check, sir. I'll check just 1 second.
Aparna madam.
Sir.
Good afternoon.
Sir, good afternoon.
Mohan Rao sir given very good opportunity to participate.
Is constitutional.
Now is it audible, sir?
Congress?
Yes, sir. Yes, sir.
The President?
Yes, sir. Audible,
The
sir.
Judiciary?
No, rewind it, madam, sir. If you
Question
don't-
arose during the very infancy of the The foundation on which rests the government of the United States is the Constitution. Like most important political documents, the Constitution is subject to interpretation. That is one of its great strengths. The Constitution is not a legal straitjacket. It is firm and yet flexible enough to meet the needs of an ever-growing, ever-changing nation. Naturally, the question arises, who is to say what the Constitution means? Who is to say, for example, whether a law enacted by Congress is constitutional or whether it is not? Congress? The President? The Judiciary? The question arose during the very infancy of the Republic. It brought face to face two eminent statesmen who have profoundly affected America as we know it today, President Thomas Jefferson and Chief Justice John Marshall. What Jefferson said was this: the voice of the people is supreme. Let the people decide through their elected representatives what the Constitution means and what it means not. What John Marshall said, on the other hand, was this: the Constitution itself intends for the federal judiciary to make that decision, men who are appointed to the bench for life and who therefore stand above party strife and political turmoil. The difference of opinion of the two men on this crucial issue was resolved within the framework of a case known as Marbury versus Madison, a case which was heard before the Supreme Court in 1803 and which led to one of the most important decisions ever made by that court. Sometime during the fall of 1801, four men decided to pay a visit to the United States Department of State. The four men's names were Marbury, Ramsey, Harper, and Howe. President Adams, during the very last days of his administration, had nominated them as justices of the peace for the District of Columbia. The Senate had confirmed them. President Adams had signed their commissions, and the then Secretary of State, John Marshall, had affixed to the commissions the seal of the United States. However, in the great flurry of activities during John Adams' exit from the political stage, these commissions had disappeared. Jefferson's Republicans were in power now. Thomas Jefferson was president, and James Madison, Secretary of State. And the commissions of Marbury, Ramsey, Harper, and Howe had still not turned up.
Gentlemen, I'm Mr. Marbury, William Marbury. Mr. Ramsey, Mr. Harper, Mr. Howe. We're here to see the Secretary of State.
On what business?
We'd prefer to put that directly to Mr. Madison.
Mr. Madison has given instructions, very strict instructions, sir, that he be informed of his visitors' business before they are admitted.
Very well, then. We're here to inquire into the whereabouts of 4 commissions, commissioned for these gentlemen and myself as justices of the peace of the District of Columbia.
The whereabouts?
That's right, the whereabouts. We know that they were signed by the president and sealed, but they were never delivered to us.
If you'll wait a moment, gentlemen.
He'll see us.
He won't.
If he doesn't, I'll make him jump. You mark my words.
Make him jump? There's little chance of that. You keep forgetting, Marbury, we lost the election. Mr. Jefferson is in charge now, and he'll play the tune, and we Federalists will do that. He lost those commissions when we lost the election, and that is that.
Well, I don't think that is that. We have a legal right to those commissions. Doesn't matter which party owns that desk.
Marbury, let's go home.
Not until he sees us.
Gentlemen, I'm Mr. Wagner, the chief clerk. The secretary has urgent business and cannot see you. He has directed me to talk to you. I'm at your service, gentlemen.
Mr. Wagner, this matter concerns the secretary himself.
He cannot be disturbed. I'm sorry. If you will be so kind as to state your business.
Mr. Wagner, the 4 of us were nominated by President Adams as Justices of the Peace for the District of Columbia.
Former President Adams.
The nominations were confirmed by the Senate. They were signed by the President, but they were never delivered to us.
I know nothing about that, nor I'm sure does anyone else here, least of all Mr. Madison. You're aware, of course, that he didn't take office until May.
I know that. However, Mr. Wagner, the commissions were last seen on a table in the State Department. Now, Mr. Madison is in charge of that department, and we intend to hold him responsible.
I doubt that he'll accept that responsibility.
Just so we don't misunderstand each other, Mr. Wagner, the withholding of an official document of the United States, commission of office, is a crime for which a man is punishable under the law, even if that man is the Secretary of State.
You're not considering, are you, taking the Secretary of State to court?
Yes, we are, Mr. Wagner. As a matter of fact, we will take him to court if that's what it takes to force this department to produce our commissions. You don't think any man is above the law, do you? The Secretary of State? The President himself? Now, Mr. Wagner, are you going to tell us about our commissions or not?
I know nothing about them, sir. Nothing at all.
So this kind of administrative, strategic, political strategic action had been questioned before the court, and the apex court was confronted with whether it can make a particular law even pursuant to a different political strategy taken by the next government in power, and whether it can invalidate a law or not. That dilemma has been cleared by the Supreme Court by invoking this doctrine of judicial review. And most of the courts all over the world, including the India, there had been adoption of this judicial review, and the democracy could be preserved by invoking this doctrine. And any law repugnant to the Constitution and the values could be declared void, and there could be protection extended to the people, and their rights are protected. And more significantly in India, through this Kesavananda Bharati verdict, the doctrine of judicial review, as well as several other basic structures which could be visualized by the judges who were standing very strong for the protection of the Constitution. That brave step of these judges who were sacrificing even a lot and who were not at all taking those consequences into consideration while they were deliberating and exercising that judicial function of interpreting the Constitution and invoking the doctrine of basic structure. And that has been preserving the Constitution intact, and we could enjoy the fruits of the constitutional values, and we could achieve the progress. Here and there could be some misgivings. And during that period of emergency, that one among the minority group of judges, he could do nothing afterwards when all the judges have been standing for the values, and the Supreme Court laudably and very aptly has been acting as guarantor of fundamental rights and the constitutional values, constitutional morality, and the constitutionalism through which we could have a very good governance, which can be even guaranteed to all the people when we stand by the value-oriented approach. And especially the law students and legal academicians are expected to scrutinize or exercise that wisdom and analyze each one of the laws that had been brought into or continued to be in force even after the commencement of the Constitution through Article 372, and the checks and balances that have been laid down by laying down a strongly worded provision like Article 13, and empowering and enabling the people to move the superior courts whenever there is a violation of fundamental rights. And the vistas of these have been taken to its logical end by invoking another doctrine, namely the public interest doctrine. And thereby we could ensure that there can be good governance established in this country, and it would flourish and make the living a happy living, and the governance good governance. And whimsical approaches are to be checked through the elite and the lawyers who have been laying the foundation for having a good law and the governance in this country by striving to achieve freedom and independence to this country. And that legacy is to be continued by the lawyers and legal fraternity when we work. And we have that task of verifying and scrutinizing every law if there is any inconsistency with any fundamental right, and we shall not keep quiet. Raise up to the occasion and try to move the court, especially the constitutional courts, whenever there is anything inadvertently affecting the fundamental rights and the values that are established by the founding fathers. And we have that award objective before us. And I appeal to each one of these lawyers and the legal fraternity that we have that job of verifying the wires of every such law, whereby the touchstones of these doctrines, the basic structures, and we need to preserve and ensure that the coming generations would enjoy the fruits of the freedom that has been achieved by several sacrifices of the founding fathers, and the present day representatives of the people and the houses, if they are not functioning properly, we are expected to set them right. And the other day there was a point raised by one of the legal academicians to the effect that the GST body or the commission is not democratically functioning, and the scheme of that itself is one-sided, tilting the balance towards more and more power vested with the center, and the finance minister and others, they enjoy that. The central government would enjoy 33% of the votes, and they can even decide even with a biased way, and they are not expected to continue that. And the democratization of every such institution that is established by the constitution, and that particular GST act also, or the functioning of that particular body also must be regularized in such a way that it is amenable to the judicial review. Nothing is above the law and the legal framework, and we are expected to do that, verify and scan. And we have even the line making that has been publicized before enacting it, or the bills are publicized in the official websites of the legislative department, and the law commission also works for it, and the public can also scrutinize and bring it to the notice of, or take it to the notice of the policy makers, that so and so provision is obnoxious, or a particular law itself is obnoxious. And with this, I request you all to work with that wisdom and try to study the constitution and try to help those deserving masses by your wisdom and appreciating these doctrines. We can do that. And thank you very much for the patient hearing. And if you have any queries, we'll have a learning experience through those queries you are going to raise.
Thank you, sir.
Yeah. And that gentleman who has
thank you
been
very much.
trying something on the screen has been continuing that.
Hello.
Yeah.
Important highlight points, sir.
Thank you
So
so much sir, for
can you
your
hear me, sir?
moving and valuable address. Now, it's time for the question and answer session. I request Ms. Gopika Hosmani, Assistant Professor, B.V.Bellad Law College, Belgavi, to conduct the session. Over to you, ma'am.
Thank you, Priya.
Shall I stop sharing?
Sir, shall I begin with the question, sir?
Hello.
Yes.
Can you hear me?
Yes.
No, 1 minute.
Just a minute, sir.
1 minute, Shashi Kumar. 1 minute. The questions are already sent in the chat box. Let our consult teacher read out them, and afterwards we can take up the oral question.
So before we go, a request to all the participants, please put your questions in the chat box.
Ma'am, certain things that cannot be put in the chat box. I appreciate it to be oral.
Okay, just wait for a few minutes, sir. Let me start with some questions, and then later on you can ask. So first question is, sir, should the Supreme Court, whether it can function as a supreme legislature or the parliamentary, so whether Supreme Court can be the supreme legislature. Participant, mute your mic.
Are you saying Supreme Court is the
Does the Supreme Court can act?
transgressing into the
Yeah.
other wing and judicial legislations have been given?
Yes, sir.
Do you mean by that?
Whether Supreme
Is
Court
that the
can
question?
supersede over the legislative powers of the parliament is the question, sir.
No. There hasn't been any such occasion for the Supreme Court to legislate. Say, for example, you have Vishakha versus state of Rajasthan, where there was no law. The Supreme Court was giving guidelines, and it has been guiding the legislature to make a law. As such, there had been several guidelines laid down by the Supreme Court while interpreting the particular law. And if there is any lacuna, even by invoking casus omissus also, it had been very slow and exercising restraint. And there hadn't been overactiveness, or though there is criticism about such things here and there. Suppose NJAC Act and the constitutional amendment was declared unconstitutional by stating that there is judicial supremacy to a particular, to some extent, and not that it has been enacting any law. And when there is a law in place, there had been judicial restraint exercised by the court.
Okay, sir. Thank you, sir.
Ma'am, I have a question.
Yes, you.
Yeah, you can.
This is Amannath from SSL College, Law College, Gulbarga. I'm fresher.
Yeah.
Can you hear me, ma'am?
Yes,
I can hear you.
Okay, so I have a question. Okay, I will talk about the suspension of 12 MLS from Maharashtra. Okay, so can legislative assembly pass the bill when these people are suspended?
Yeah, actually, what happened? You must have been following the news, and even you may even read the 90-page judgment that has been delivered by the Supreme Court yesterday.
Okay.
Actually,
no,
what
sir,
happened
no,
was
my
that.
question. No, okay. No, my question.
Let me just.
Okay, I'm sorry. Go ahead, sir.
There was a House resolution suspending the MLAs for 1 year, and what the court today, invoking the doctrine of judicial review, stated is that there was excessive action by you, because 6 months duration has been prescribed by law under the Constitution for any reason whatsoever. There can be a vacant post also could be filled in within a span of 6 months, and the procedure followed by the House in tune with the House of Commons of England, and that procedure, if you can take all corrective actions, but there ought to be the limit for one session, and it did not go into the wires of the action and the and whether the alleged action was proper or improper of the MLAs or not.
Sorry to interrupt you, sir.
Yeah.
Sorry to interrupt you. Okay. The Supreme Court says the session was for 10 days. Okay. So the MLAs were suspended on day 3. So they were suspended totally for 7 days. It's an example. During that period, can any bill, say for example, let me take my own Karnataka, Hyderabad, Karnataka region. If 12 MLAs are suspended on day 3, so there are only 7 days. So no MLA is representing. from Hyderabad, Karnataka region. So we were fighting for Article 371J for special quota, right? So Supreme Court says you can suspend them for remaining session during those 7 days. If my MLS are not available from Hyderabad, Karnataka region, who is going to ask for the Article 331J?
That's what. That's what.
There
Actually,
is no mention in the order. I have read thrice.
yeah.
It talks more about.
My dear friend, it should have been raised by the council. And that kind of, suppose you have a valid point, you need to move the court with
I'm
that
precious,
specific question.
Just 3 months old to the SSL Law College, Gulbarga.
Yeah, that I understand and appreciate. Anyway,
And
the
the
thing is that
second thing is the judgment talks
no, here,
more about the
when you
MLS
raise
than the
something,
people.
when you raise something, you need to have the patience of hearing to us when answering.
I'm sorry, sir. Go ahead.
You were talking about that action of the House adversely affecting the democratic process.
Right.
That's what taking that, invoking that democracy as a basic structure of the Constitution only. The court has gone to the extent of saying that your power to discipline the members is reasonably curtailed to the extent of suspending them to the maximum for one session. During that session itself, if you have some bills to come, and you are expected to exercise such restraint and be proper in. And what had happened in the Maharashtra Assembly, there was some objectionable behavior by the MLS, and nobody is supporting those people. And now today, even the court did not go into the merits of that, but it could go into the wires if when the rights are affected, and when the basic structures are affected by the action of even the House. This is the first time in the judicial history that the Supreme Court has usurped its power, and it had laid down to the effect that the suspension is not proper.
So instead of suspension, it could have given us some other punishment for the remaining session. I was just thinking about any bills.
Mr. Thomas.
That is the
Mr. Thomas,
prerogative of the House.
Yes, sir.
Let me interfere, Mohan. Just want to clarify, Thomas, that see, when the legislature, suspending the legislature is within the power of the speaker, the presiding officer of the House. In case if any member behaves abnormally or not inconsistent with the legislative principles or legislative discipline norms, he can be suspended by the speaker. There is no doubt about it. And when the MLs are suspended, can the bill be passed? Again, is a question of technicality. Again, see, a bill will get passed when the majority of the members pass it. Whenever there is a quorum, and if the majority of them approves the bill gets passed. That's all. So there is nothing to do with the passing of the bill and suspension of the MLS. And as Dr. Mohan was emphatic in his talk that the Supreme Court did not go into the merits. Whether their suspension is valid or not, the Supreme Court did not test that. What Supreme Court tested is whether the speaker was in excess of his authority in suspending the MLS. That's all. That is only the crux of the issue that has been taken to Supreme Court. It's not whether right or not to suspend them or not from the House that has been involved. Okay. Now let's move on because we have to move on with other questions. Okay. Thank you very much.
Thank you. Sorry, sir.
Yeah, good.
Thank
good.
you.
No problem.
Thank you for the
Don't
information.
have to say sorry. You have
Thank you, sir.
expressed your
Thank you, sir.
views, and I'm also learning.
Yes, go ahead because there are
Thank you,
plenty
sir.
of
Thank you
questions.
for the clarification, sir. Sir, next question is there any time limit for judicial review?
No, there is no such thing. We have in the Constitution. Nowhere it is laid down to the effect that there ought to be a time limit within which one can raise the issue before the court. It is a question of violation of fundamental rights, and
Yes.
the wires of wires of any act, even pre-existing law, we can question at any point of time, and there is no time limit as such. The court, you need to go to the court with such justification that your rights are violated, and by and large now with the advent of public interest litigation, we can even take the help by saying that the public interest and social interest is affected, and that there is no such limitation.
Yes. Sir, it can be a appealable matter, whether we can file appeal against the review. Some participants are asking with respect to appeal matter. Judicial review can be challenged before the Supreme Court or High Court for appeal.
I did not get the point actually.
Whether judicial review, once the judge is going to review the matter.
Even in the appellate, exercising the appellate jurisdiction also, that is what even categorically laid down by the Supreme Court in L. Chandrakumar.
Yes.
Yes.
Wherein the even judicial decisions also are subject to scrutiny. And therefore, even in the appeal matters or matters of appeal, the court can verify. And there were several occasions for the court to exercise this and scrutinize the law and say that the law is not properly drafted even at times.
Thank you, sir. The next question is, judicial review may allow the judges to overlook the challenges of changing times and make them more conservative. What is your opinion with regard to this, sir?
Yeah, there can be such a situation. Say, for example, in Suresh Kumar Kaushal case, initially the court was invoking the doctrine of constitutionalism and the presumption that the law is constitutionally valid. The long ago enacted and the social milieu hadn't been considered, and it had been reviewed by the Supreme Court at a later point of time. There could be some such conservative opinions expressed by, and at times we wonder there could be conservative opinions, and there could be even some named as conservative judges. all judges are not like Justice V.R. Krishna or Bhagwati, who had been pragmatic, and liberalist way of approach by all the judges cannot be contemplated. Say there had been several such guidelines that have been laid down by the Supreme Court that are not implemented by the administration, and it is taking its own time, and again the court has to pass strictures against the government also. However, your point is well appreciated, and there are such and such occasions where it also, see, one more thing is that it also depends upon the counsel who can convince the judge and take the matter to a proper platform in a proper perspective and appreciate. I can give you one example. You have the Protection of Women from Domestic Violence Act enacted in 2005. In our Karnataka High Court, there was a man moving the court. That is that also he was urging the court to extend the benefit of that which is provided under the Domestic Violence Act.
In fact, the first case under
the court, speaking through Justice Anand Bhaira Reddy, got convinced that it is not only the women, there can be the protection can be extended to men. Nowadays, there is domestic violence and there is no sexual discrimination, and men are also equally suffering. It is now and then we are coming across such cases, and there is possibility. It depends upon the articulation, power of articulation and convincing and appealing way of presenting the case. Yeah, Jaisima sir was saying something.
Yeah, even
did you come across any such instance where men are abused?
No, I was just reminding that when Domestic Violence Act was passed, the first case under the act was passed in Tamil Nadu by a man.
Yeah.
And General Clause Act also prescribes man includes woman.
Generally, but when we look into the when we invoke purposive rule of interpretation, it cannot be extended. But thanks to the wisdom of the Supreme Court, that it has been taking up matters so generously, and the protection that is contemplated under the Domestic Violence Act has been confined, restricted, and actually the constitutional validity of that act was in question with respect to the definition of respondent provided in section 2Q of the act.
Yes.
Earlier, before the court had struck down a part of that particular provision, the initial definition given to respondent under section 2Q of the Domestic Violence Act was any adult male person. It conveys, or it is understandable that whether an adult female person can resort to domestic violence, and on the other hand, a juvenile can cause domestic violence, and they are not brought into the clutches of law. They got that freedom. But with the advent of the verdict given by Rohinton Nariman in that Narottam case, wherein that part of that particular definition, invoking the doctrine of severability, adult male has been struck down as unconstitutional, and any person causing domestic violence is held. Now, as the position stands, it can be any person causing domestic violence. He can be the respondent, and there can be initiation of proceedings against them. Yeah.
Thank you so much for your clarification, sir. Thank you so much.
Sir, one question. Sir, one question.
Yes. Yeah, you can ask.
Sir, what are the grounds for judicial review?
See, as Article 13 categorically says, if there is any fundamental right violated with the advent of any law, you can invoke the doctrine of judicial review, and you can question that, and invoking the jurisdiction of the High Court under Article 226 or Article 232, we can move the Constitutional Court and challenge the validity of that particular act.
Okay, sir. Thank you.
Thank you for your clarification, sir. Over to Priya.
Oh, very
Thank
good,
you,
and
ma'am.
very kind of you for raising such wonderful questions, and I have a learning experience here.
Thank you.
In this platform, and time is the constraint, and I could have even been deliberating on several doctrines and the doctrinaire. Anyway, we look forward for such other occasions to deal with some other subject, and very kind of you.
Thank you, sir. I request Dr. Supriya Swami, Assistant Professor, B.V.Bellad Law College, Belgavi, to propose vote of thanks. Over to you, ma'am.
Thank you, Priya. Good afternoon, everybody. Respected chief guest of today's webinar, principal sir, participants, faculty members, and my dear students. I deem it my privilege to propose vote of thanks to this national webinar on the topic Judicial Review, a basic structure of Indian Constitution. So I, on behalf of Cayley Society's B.V.Bellad Law College, principal, staff, and students, and on behalf of all the participants, extend my deep sense of gratitude to Professor Dr. Mohan R. Bolla, Principal, Christu Jayanti College of Law, Bengaluru, who has kindly consented to be the chief guest of today's webinar and for delivering thought-provoking speech. So really, more than 500 participants are enriched with your valuable address, both on Zoom as well as on YouTube link, sir.
Very kind of you. And I don't know whether Jaisimha sir, why did he choose me for this?
I come to you later. I come to you.
Thank you.
Thank you so much, sir.
Thank you very much for giving me the opportunity.
Thank you. Thank you so much, sir. I thank our respected principal, sir, Dr. B. Jaisimha, for being for his encouragement and for being the source of inspiration in organizing all endeavors of a college. Thank you, sir. I take this opportunity to thank all the participants who have joined this webinar from 12 states: Karnataka, Maharashtra, Goa, Haryana, Andhra Pradesh, Himachal Pradesh, Uttar Pradesh, Kerala, New Delhi, Telangana, Bihar, and Tamil Nadu, and making it a grand success. Thank you so much. I thank all the faculty members for their constant support and cooperation in organizing this event. Thank you. I thank Mr. Ram Kishan for his technical support. Thank you, Ram Kishan. I thank Priya Shapurkar, student of 2nd LLB, for comparing the program. Once again, I thank one and all. Thank you so much.
I must tell 1 minute. I must tell the secret why I invited Mohan here, because Mohan took me to n number of webinars during the last COVID and had given me an opportunity of enriching myself and participating both as resource person and also as a participant there. So I thought that let me begin this webinar of this year first with my dear friend Mohan Rao. And I wish to inform all those my Andhra Pradesh friends, because I do belong to Andhra Pradesh. Let me start with my state academician and move on. Thank you, Mohan. It was really a scintillating talk on the topic. I know that the topic doesn't have any boundaries or any limits there. We can discuss the topic for n number of
we look forward for such sessions, more and more such sessions.
Yes,
we can have.
Yes. And
anyway,
happy to
thank you very much.
Happy that you accepted my invitation, and thank you very much. We look forward for your presence in our future endeavors. Thank you, and wish your college and father there all the best, because you hosted me twice when I came to your college as a part of
it's our
that outstanding reception that I had in your college when I visited your institution. Thank you very much.
Thank you.
Thank you, sir. Thank you so much. Dear participants, the feedback link will be posted in your respective WhatsApp groups.
Yeah.
Thank you. Thank you, everybody.
Yes, very kind of you for the wonderful session. Thank you. Looking forward for meeting you personally.
Hello.
Sure.
Hello.
Yeah, there is somebody raising the
voice.
Thank you, sir. Thank you very much, sir.
Thank you.
Hello. Hello.
Sangmesh, tell me. Mute Marbury. Unmute Marbury. Yes, Sangmesh.
Hello. Hello.
Hello.
Hello.
Hello.
Hello.